Number 351, and we said we were going to come back this morning to continue with 343. And I had left off with Senator Blas, and he said he was already had resolved it with the chairperson or the sponsor. And,
yes, Speaker. Madam Speaker, we have 3 amendments.
Oh, you do have 3 amendments? So
for based on our conversation, yes.
Okay, so maybe we'll wait until he returns, or do you want to do it now? He said he was okay? We need to do it now? Okay. Well, that's what I was going to say, is that after Senator Blas, I had Senator Esprodon had asked to be given an opportunity to come back, and so that's where we're at this morning then. So, Senator Esprodon, you're recognized.
Madam Speaker, before we go any further, because of the amendments that are proposed to being proffered, if I could, I would still like to have the amendments proffered so that we don't have to go further, because I think some of these amendments may address some of the issues that I was going to raise. So I think it would probably be more appropriate, Madam Speaker, to allow the sponsor to make those amendments.
Okay, so, and Senator Blas was okay. He had worked with you on those amendments. Okay, all right, so we'll go ahead then.
Thank you, Madam Speaker. Madam Speaker, thank you for giving us the opportunity to work some amendments with our colleagues. And I have 3 amendments, Madam Speaker, to include in this Bill 343-33. And the first one will be on page 1. And it's to add a new Section 1 to the bill to read, Section 1, Legislative Findings and Intent. Recognizing that the Supreme Court of Guam, in request of Imina 32 na Legislatura en Guam, relative to the power of the legislature to prescribe by statute the conditions and procedures pursuant to which the right of referendum of the people of Guam shall be exercised, 2014 Guam 24, effectively paved the way for the legalization of medicinal marijuana in the territory by allowing the legislature to submit the question, quote, shall the Wakin KC Conception, the Second Compassionate Cannabis Use Act of 2013 that provides for the medicinal use of cannabis be allowed, close parentheses with a question mark, on the ballot in November 2014 Guam Election Commission. So that would be the amendment. And then the second paragraph, Legislatura Guam finds that on November 4th, 2014, at a general election duly held in the territory of Guam, the people of Guam voted to legalize the use of medicinal marijuana through the Wakin KC Conception, the Second Compassionate Cannabis Use Act of 2013. In an effort to strengthen the provisions of said act, the legislature, after extensive deliberations with the people, find that the following revisions better and more fully effectuate the intent of the law to alleviate symptoms caused by debilitating medical conditions and their medical treatment. That would be the First Amendment.
On the First Amendment, are there any discussions? No. Any objections? No objections then, so ordered. Thank you, Senator. On the Second Amendment?
The Second Amendment, Madam Speaker, is on page 31, lines 16 through 17. After the word operations.
Okay, page 31. Line 16 and 17, okay, after the word operations.
Comma, and then as determined by the Department's rules and regulations.
Okay, so that it's putting it right back in.
Yeah.
Okay, on that amendment, any discussion? No objections? So ordered.
And then the third amendment, which the good senator from Barragata talked about the seizing of the cannabis and what is forfeited. He wanted to make sure that the provisions were clear. And then on line 22, page 43, after department is authorized to seize, add and destroy all forfeited cannabis products in accordance with section 122521 of this act.
On the amendment? No objections? So ordered.
Madam Speaker, I do know that you have
Yes, I don't know what page that is on.
it's on page 50, but we do have a Madam Speaker, if I may just have a minute, I know this is your amendment, but
Yeah. Well,
we
no,
do have
we'll do it later on. Yeah, we'll just go ahead and move on to,
okay.
okay, because I don't want to delay this any longer. Senator Espodan, are you now ready?
Madam Speaker, there's been a lot of good work that's been put into this, and actually it's been in, I know that this bill was partially adopted for the most part adopted from the good work that was done at the Department of Public Health and Social Services, and then on top of it, all the meetings and roundtables and bill markup sessions that the good author had conducted. There are probably a few small items, but I think that would be a little bit, I guess one thing I do realize, Madam Speaker, because it's such a new policy and we're trying to at least put some meat around the bones, that sometimes we don't really understand the effects of some of the provisions in a bill until actually it's implemented. And so at this point, Madam Speaker, I went through it again several times last night, and I really have no real big objections as is. Some of those amendments that were made just prior, I think addressed some of the issues that I wanted to bring up. So at this time, Madam Speaker, I do not have any further questions, and I thank you for the opportunity. And I thank the sponsor for working with the good senator from Barragata to address those issues. Thank you, Madam Speaker.
Thank you, Senator, as well. Appreciate that. Is there anyone else who would like an opportunity to speak on the motion? You do have one more thing?
I'm sorry, Madam Speaker. There was one issue that I think that needs to be asked, and if I may, I should have probably forwarded the question, but it was a question that was raised by the Director of Department of Public Health. Okay. And it was the issue of the quantity, where he basically says that, while the amount is specified at 2.5 ounces, it no longer states a time period in which you can hold it. And I guess that's always been one of the curiosities in my mind, too, that if a patient has availed himself of 2.5 ounces and say, for example, he uses 1 ounce, and so he has 1.5 ounces left. At that point, is he allowed, or is that patient allowed, to then replenish up to 2.5? In other words, there'll be a continuing amount of 2.5 if that is the practice of 2.5 ounces.
I know normally when we think about a prescription that we're given and we choose to cut it in half, I think the original number stays on as a continual refilling of that prescription. What the patient does with it now is a different story.
Right. Well, is that the answer?
Yes, I'm just trying to formulate.
And I agree. I mean,
in my mind,
you're right.
exactly what.
You're right. If I had a prescription and I used half,
Yes.
then I really don't go to get a refill until I utilize
You're right,
the
yeah.
full.
Yes.
Yeah,
Okay.
the
Senator,
answer
do
is
you yield to the
yes.
question?
The answer is yes. The limit is at 2.5. The patient can possess up to 2.5 ounces at any given time.
Okay, just up to 2.5, no more than that.
Not no more.
By law.
And so I would imagine that the practitioner who writes for the patient, a certification for the patient, would, because when the physician right now prescribes some medicine, right, he'll put, X amount of doses for 13 days or 14 days and with 2 refills type thing.
Yes.
I would imagine this would be a different kind of prescription that he would write. It would be an open-ended.
Okay, Senator, can you respond to that?
Thank you to the good senator. Because it's not a prescription, it's a certification. The department, so the limit is 2.5, and the patient can possess up to 2.5 at the given time. So he's saying, is it a prescription? Is there a limit? It's the doctors can't prescribe. They can give a written certification, then it gets sent to the Department of Public Health.
No, I didn't know that. Senator.
The doctors aren't able to prescribe because of the federal provisions that are still in place. So the doctors, practitioners can only give a written certification to their patient that they can utilize this alternative because it will best suit their debilitating health issue.
And they take that certificate into public health?
Yes.
Then public health.
Will follow the guidelines to work it through.
So public health then takes it, and then I guess they verify it and puts it on file. And then with that, then the patient then can go to a dispensary, I would imagine, and purchase the amount with an authorization card of some sort.
Yes.
Right. And again, for the viewing audience out there, I think that they want to try to follow the process of how this is going to happen. There are a lot of people who are looking forward to this. And so, again, I just want to go through the process, or went through the process. I wanted to go through the process to try to give them some comfort of, because that was an issue that was brought up. How does it all come about now? And I appreciate that, Madam Speaker. Thank you.
Well, thank you for bringing that up as well. Senator Torres, you're recognized.
Madam Speaker, I'm looking at and talking about the processes. One of the concerns that many of us had in the beginning was whether there'd be proper labeling of the product so that the patients have an understanding of the product that they're purchasing and the medicinal properties of those products. And I have a little bit of concern, and perhaps I just would ask the author of this legislation if she can clarify. On page 62, line 17, section 122529, testing laboratories unidentified. In this provision, it provides that, notwithstanding any provisions of law, if there are no licensed medical cannabis testing laboratories after 120 days of the enactment of this act, all licensed medical cannabis business must place a label on the product, essentially stating that the medical cannabis product has not been tested or approved by the Department of Public Health and Social Services, and consume at your own risk. And then it also provides further that the testing requirements and the chain of custody forms where it goes through the department is exempted. And is this intended then as a loophole whereby if in 120 days, if there are no testing laboratories on Guam, then essentially we have medicinal marijuana that will be provided that has no indication to the consumer what the strain of product is, what the different properties of the product is, what the benefits to their particular symptoms are with use of the product. In other words, there's no guarantee, or there's no sense of regulation in essence with this provision. And what my question to I understand the rationale, medicinal marijuana is needed. If there's no testing, let it be available, notwithstanding. But my question to the author is, with this section in there, essentially, if there's no incentive or there's no push to having a laboratory, in my estimate, it seems like we're providing that, well, if we don't do it by this day, then, hey, just put it out there anyways, but just tell them to consume it at their own risk. I don't know that that's necessarily what we envisioned with medicinal marijuana. We wanted to have a system where, in fact, the dispensaries can have labeling, can have certain properties, and can have a tie-in to the medicinal benefits of the various types of products. What this does is it essentially allows it to happen, but it doesn't. There's nothing to suggest that at some point we want to have laboratories on Guam, and I've not seen where we have a conditional granting of an exemption, but that we ultimately want to arrive at a situation where it is clearly, the product is clearly regulated and absolutely tested for all those reasons that we felt testing was necessary with any drug or medicinal type of herb. So to the author, is it contemplated anywhere in your thoughts or in the work of the committee or the various people who contributed to this legislation to arrive at a place where we have laboratories? Because what this says is within 120 days, if we don't meet that mark, we may indefinitely go without a laboratory. And I don't know that if I were a patient that I would necessarily want to chance, I would like to pay for something where I had at least a sense that it's what I'm paying for, that if I'm paying for a product, I would expect that the product has some promise of an effect, of some promise of a benefit to me if I were to pay money. So how do you, and I'm not objecting, I'm just trying to clarify.
I can understand the concern, and thank you to the good senator from Santa Rita. On page 58, on 1225268, testing laboratories, the department shall license one or more independent medical cannabis testing laboratories. So there is a mandate that says the department shall. When this section was provided, Madam Speaker, it was to give the patient the much needed access to the use of medicinal cannabis if the government again failed to follow through with the program. But again, I can understand the concern, and if there's a motion to delete, then we'll take it from there.
Okay, Senator, are you satisfied with the answer? We're going to take a brief recess. The legislature is back in session. Senator Torres, you still have the floor.
Thank you, Madam Speaker. I'd also like to thank the author of the legislation for discussing this concern with me. And I'd like to, at this point, Madam Speaker, move to strike Section 1225279.
What page?
Page 62, beginning at line 17, through page 63, ending at line 21. 1 to 21 on page 63, and line 17 to 26 on page 62.
So lines from line 17 to 21.
26 on page 62.
62.
Line 17 to 26.
Oh, to 26. Okay, all the way. Yes.
And on page 63, line 1 through 21.
1 to 21. Oh, so it's the entire section.
Correct.
Okay, on the amendment, everyone, page 62, starting on page 62, line 17 to 26, which is that entire section of 1, 2, 2, 5, 2, 9. And then page 63, everything from lines 1 to 21. Does everyone understand that? What we're deleting? We're deleting that entire section. Yes? Any discussion? No objections? So ordered. Yes, wait, who? Please, okay, Senator Haddad. I'm sorry. I only heard a voice, but I didn't. Okay, but you want to speak on something else? Sure, but please, can you get on the mic then?
So I just need to make sure I understand. It seemed that when the concern was raised about that particular section 122529, a response was given that there's actually on page 59 there.
On page what, 59?
Yeah, so under 125528, subparagraph C, that the department shall establish, oops, no, that wasn't the one. Oh, 122528A, the department shall license one or more independent medical testing laboratories. And I thought I understood it said that was the mandate, that there will be a testing laboratory that will be licensed, if I'm correct. And maybe this is if the author would yield to clarify them for me, that the department shall license one or more if there is one that steps up to be licensed. And so it seemed that based on this, there was the I guess the concurrence to go ahead and delete that section 122529, because there's a mandate here that the department shall license. But I mean, it shall license one if there is one to be licensed.
Senator,
So
do you
maybe
yield
if
to the question? Can you repeat your question to me? Can we hear the conversation? Otherwise, we're going to take a brief recess. Okay, recess.
Yeah, I would say keep it at medical, anywhere.
The legislature is back in session.
We want medical.
Senator Spaldon and Senator Ada
medical.
and Senator Torres, you're all done. And so I'm going to move forward now with Senator Frank Blas.
Hey, Jesus Christ. Madam Speaker, I just propose basically a technical amendment.
Okay.
There is a distinct difference between the utilization of the words medical and medicinal. Medical basically refers to that being used for treatment for medical purposes. Medicinal basically says the practice of medicine, and it could be otherwise. It could be broader. So for that purposes, recognizing what this is for medical marijuana. Is
there a specific section that you're addressing?
No, there's no specific. I just want to make sure that in all cases, we're talking about medical marijuana, not medicinal marijuana. So I just want to make sure that we cross our T's and dot our I's, and making sure that every reference to
every reference, you're
if
right,
there's
to
medicinal, it should be medical.
Okay, so to make sure that it says medical cannabis, is that
Right.
what you're trying to say?
As opposed to medicinal.
As opposed to medicinal, okay. Yes.
Well, then, just earlier we made an amendment in section 1 there that talks about the.
Can you tell me what page, please?
Well, no, this is the amendment that was put in earlier to put in a new line 2, page 1, which makes reference to a Guam Supreme Court judgment, which effectively paved the way for the legalization of medicinal marijuana. Now, the gentleman here is wanting to change it to medical marijuana. So what are we dealing with?
I apologize. I'll don't blame legal counsel and everything. We had this discussion yesterday. It's just that later on in the day, and then this morning, I had some issue with regards to the difference in definition between medicinal and medical. Okay, and doing the research, and basically seeing throughout. I just want to make sure that throughout the.
Okay, so can we authorize then legal counsel to make sure then that throughout the bill,
Right.
Whichever then is correct, whether it's medicinal marijuana or medical cannabis, because I'm seeing that also written throughout the bill, but throughout the bills to make sure that we use that one term that is correct. Senator Espadon, yes.
Madam Speaker, with that suggestion, may I just offer a suggestion before that?
Okay.
And perhaps allow legal counsel right now to perhaps explain to us what the fine line distinction is between medicinal and medical.
And
I agree with that.
I mean, in that way we have at least the legal counsel's...
because there is,
look.
I know they're kind of used interchangeably. The
Right.
way I'm seeing this, like I read, I'm reading throughout the bill, I see the words medical cannabis.
Right.
I know, and then in the beginning we have medicinal marijuana, and that's where we need to make sure that the language will be consistent throughout.
Right,
Yes.
and based upon the argument of the author of this amendment, it might be wise to ask legal counsel right now if there is a fine line
Okay,
distinction
so
to understand what each represents.
Yes, so I'll just take a brief recess to get that.
Thank you.
The legislature is back in session. Senator Blas, legal counsel, have already made that determination.
For the purposes, ma'am, of being very clear with my amendment, is that to allow the powers that be to change every reference or word medicinal to medical, to include the use of the word medicinal in the previous amendment that was passed by this body.
Okay. On that motion, no objection, so ordered. And the motion, Senator, you want to close or, okay.
Madam Speaker. Madam Speaker, I just want to say I want to thank my colleagues for taking the time to make the necessary provisions, but more importantly, to talk about the access to medical marijuana for all those patients that are truly, truly suffering from debilitating health issues. Will finally move forward and put this program, have this program implemented to make sure that our patients that are truly suffering will have the access there too. I want to take the time to thank all the community residents and the nonprofit organizations that took us through this journey for the last couple of years, or several years at that, to make sure that we provide affordable and safe medical marijuana to our patients who truly need it. So thank you, and I ask that this bill go down to third reading voting file.
So on the motion to send 343-33 to the third reading without any objection, so ordered. Thank you very much, Senators. Most of the bills have come in, and I normally always try to go back, but I did promise the two senators, Agun and Centrada, to address your bills this morning. So let me see, in the order of the number will be the one that you asked for, both of you had asked for, was Senator Ada and Senator Agun. It was 318 and 335. Those were the two. Okay, so no, because I promised that yesterday to the two senators that we discussed this morning before your bill, but we did yours first. So I will do 318 and 335 this morning. So Senator Agun and 318.
Buenos dias, Madam Speaker, and to all of our fellow colleagues. Good morning, Madam Speaker. Madam Speaker, I'd like to move for the placement of Bill number 318-33 COR into the third reading file.
And that's as substituted?
As substituted by the primary sponsor.
Okay. You may proceed, Senator.
First of all, just for the information of the audience who are watching this particular caption on Bill number 318, the title is relative to requiring the support of municipal planning councils for variance applications and zone changes. And I'm going to read the additional verbiage that's added into the code, Madam Speaker. This is part of section 61105 pertaining to vote requirements for the commission, municipal planning council support requirement for approval of variance applications and zone changes. This is in Article 1, Chapter 61 of Title 21 of the Guam Code Annotated. And the verbiage that is being incorporated in here, Madam Speaker, is all approvals by the Commission for variance applications and zone changes shall be accompanied by affirmative support in the form of a resolution by the Municipal Planning Council of each municipal district to be affected by such actions pursuant to 4 GCA subsection 40128F and 21 GCA subsection 61623 and 61638. Any approval by the Commission not accompanied by an affirmative resolution from the relevant Municipal Planning Council shall be invalid. Madam Speaker, this particular piece of legislation, I want to, first of all, thank the proponents, the individuals who approached my office and asked for consideration that this proposal be put before the legislative body for consideration. And it's originated directly from a situation, Madam Speaker, where in fact there was a zone variance application. And the municipality in which the property was going to be developed and the adjacent municipality, the adjacent villages, I mean, I can refer to it directly because it's in the record books, but the Pago Bay proposed development. The Municipal Planning Council in Jotnia, inclusive of the Municipal Planning Council in Chalampago, both stepped forward. They passed a resolution opposing the variance change. In addition to that, they took it one step further. They brought the issue before the Mayor's Council of Guam, Madam Speaker, and the Mayor's Council of Guam, based on the explanations presented to them by their colleague, their respective mayors of these villages, also passed a resolution opposing the development variance request. Incidentally, after that, a few months later, the Guam Land Use Commission proceeded and approved that application. And you know, Madam Speaker, sometimes I have to resort to reminders of exactly what the government is in existence for and why we stand here repeatedly every single day advocating for issues in which would directly affect our community. And I looked up the word democracy. And Madam Speaker, the definition, just for my edification and those who are watching, is democracy's definition is government by the people. It also includes a government in which the supreme power is vested in the people and exercised by them directly or indirectly through a system of representation. And Madam Speaker, because of that situation that I just highlighted, this legislation came about that says fundamentally that if any developer is to request a variance change or a zone change, that the municipal planning councils should be at the forefront of consideration when it comes to approving or at least providing an affirmative support of that particular development or variance zone change or variance change. Madam Speaker, during the course of the public hearing, there were 25 individuals that provided testimony in support of the proposed measure. And there were 5 individuals who were present during the public hearing and opposed the measure, albeit 4 of them were members of the Guam Land Use Commission. And you know, Madam Speaker, you look at this proposal, and one of the questions that was posed to me on a side conversation was, why would you want to take the authority away from the Guam Land Use Commission and give it to the Municipal Planning Council members? And it hits at the core of this particular measure, Madam Speaker. It is giving the people, the residents in that village or in that municipality, the opportunity and the empowerment so that they can consider and approve developments and variance and zone changes in their own village. You ask the reason why. Because the reality is that that developer or that development, even if it's a rezone change to a 4-unit apartment, is going to directly impact the quality of life in that particular village. Why? Because if it's a major developer, it's going to impact the infrastructure, the roadway, the water connections, the water line connections, the power consumption. It will impact to some extent the quality of life of the residents in that community. And you know, Madam Speaker, when you look at it from, at least for me, you listen to these individuals who came out very actively on behalf of their municipality, Also, many of the mayors, southern mayors, appeared at the hearing and provided testimony in support of this because they want to ensure that they are part of the process whenever a developer comes in and proposes a zone change or a variance change. And you know, Madam Speaker, there was a conversation I had shortly before, maybe about 2 months ago, with a business developer. And this individual said, wouldn't that be anti-development? How would this be anti-development, Madam Speaker? How would this be anti-development? Even in a zone change, today, the process today requires that, in fact, if you're going to change your zone, even through the Guam Department of Land Management or the Guam Land Use Commission, within a 500-foot radius, every single landowner has to be notified of that proposed zone change or variance change. Why? So that they can raise concerns or they can support that initiative or that developer. So this is not a new concept, Madam Speaker. This is taking it to the village level. This is taking it to the mayors and the municipal council level. This is empowering our people, rightfully so, in their respective villages. And you know, to me, Madam Speaker, it is perhaps a modification in the mindset because we're so used to this process, the existing process where 5 individuals, or in this case, 5 individuals are approved and confirmed by the legislative body and they make decisions on behalf of the entire community. The process that has worked to date. But it's proven that it has its faults. And one major example is what I shared with you. So if a government, going back to democracy, is to represent its people directly or indirectly, then we need to make sure that if an opportunity presents itself to allow for direct representation from the village level to the municipal planning councils and the respective mayors, then let's empower them. Let's give them that opportunity to be part of the process and ensure that they acknowledge whatever zone change, whatever variance change, whatever development is coming into their village or could be right next door, and understand exactly what the implications would be or the benefits would be for that particular village. So, Madam Speaker, I ask for your consideration and your support for this piece of legislation. I certainly hope you can advocate for it. But, you know, it really hits, again, at the heart of why we are here. We are acting at the behest on behalf of the people of Guam. And here in this case, we're bringing it closer. Should this proposal muster sufficient support and pass, we're bringing it closer to the people who will be directly impacted, giving it to the residents of that municipality. So, Madam Speaker, I ask for your support and your consideration. And fellow colleagues, I ask you also for your support. Thank you very much.
You're welcome, Senator. On the motion, Senator Morrison, you recognize.
Thank you, Madam Speaker. I appreciate the opportunity to comment on Bill 318 as substituted by the sponsor, and my remarks also touch on a similar measure, Madam Speaker, Bill 335 as amended by the committee. Bill 318 is one of those several measures aimed at building upon the progress we've made this year to provide additional opportunities to residents to offer input relative to land use. Madam Speaker, I've never seen, at least in my lifetime, this much of our people engaged in land use issues throughout our island, particularly in our central and our southern communities. With Public Law 33-139 in place, a minimum of 2 public meetings at the village level for proposed projects under review by the Guam Land Use Commissions are now required. Another Public Law 33-145, helps us to finally move forward with the Southern Development Master Plan and to avoid further spot zoning and rezoning, height variances, requests, etc. Madam Speaker, I believe that Bill 318 as substituted is a significant step forward in our efforts to empower residents through their respective mayors and municipal planning councils. Like Bill 335 and other related measures, Bill 318 helps us to establish an improved land development review and approval structure that currently is in place. Unlike existing process, Madam Speaker, the structure proposed by 318 and also 335 ensures that resolutions actually carry weight. As in the case of Bill 335, 318 seeks to promote a process that is truly fair and upfront to potential investors by encouraging communication with affected communities at the front end. And it creates a real opportunity for economic growth to be consistent with the needs and desires of residents and the established characters of our villages. So, Madam Speaker, I feel, I know I spoke briefly on a measure that is forthcoming, Bill 335, but at 318, I can say that working with both the authors, they seem to, with their work been put involved with both measures, they seem to complement each other, both measures. I do hope, Madam Speaker, that our people continue to engage in land use projects or land use issues throughout our community, and to ensure that there is responsible practices, responsible development throughout our communities. I hope that with property owners, with respect to property owners' rights, respect to those who wish and have already been planning, and investors and developers working with our people, that these measures are seek to bring clarity and how we can move forward, particularly in our southern communities. As we all know, a lot of this has been a result of issues that took place, particularly in Ordut or Pago Bay, and some projects, large-scale projects proposed in Agat. So I'm grateful for our community, our mayors and some of the MPC members who have participated in this process. I'm grateful to organizations such as Save Southern Guam, organizations, even organizations of input that have been provided by GAR, the Guam Association of Realtors, who've also provided input. And you know, I hope that the individuals of these organizations would see fit that these measures actually have a lot of good going forward to ensure that there is in clarity going forward. I certainly don't want to see investors, developers, and our citizens always going through, although it's part of the process, I certainly don't want to see with every land use projects or proposed projects that there's so much backlash and we end up in court. That's, although it's part of the process, it's not where we want our community to be. So I thank you, Madam Speaker, for the opportunity to speak on this measure, and I thank the author for allowing me to co-sponsor this measure.
Senator Tometa, you recognize.
Thank you, Madam Speaker. Madam Speaker, no usupoputes di Zahu I hinasonya esti Bill 318 sa magahit adzawit sa talii na tidinansi hafag tamanu no mo na matsutsugi pago zanging gwaha hafa po mahatsay gisengsung no debi na itaw isengsung u po decidi hafa no malago niya ko para tahatsay sti dangkulo na hotel pat ahi pago na manera zangin guahao developer malum malago po fan hatsa no edza podetnya I mayot zani municipal planning council po atan sa zangin leknya no tizahu sti no recommendation na podetnya pues manahono zo manai ila Guam Land Use Commission pues los otros siya lamun ko pro masedi I development pad ahi Pues magahit na edzi itutuhon na sti na bill ni nu namanagwaha sa pudi edzi iporo mahatsay gid sa Pago Bay nu esta lignya tauto isengsung ti man contento na debi de po mahatsay zo lo después ani nahanaw hulog Guam Land Use Commission ma-apreba. Pues no nisita ta tulay ka na na klasen hinasu. Okay, Madam Speaker, let me speak in English now. But that was my effort at practicing our language every day at every session so that we keep this language alive. So first of all, I really want to recognize the advocacy group that stayed pressing this particular issue about giving the power to the municipalities to decide what development goes on in their municipality, in their village. And that was the Save Southern Guam group. They were very steadfast. They were out there. In fact, when we had meetings around the village, they went to every meeting and made sure that their points were being raised about how decisions were being made. Now, it's true that in the case of the Pago Bay development, although the residents of the village came out, or even the advocacy group came out and says, we don't want this in southern Guam. We don't want a 10-story facility blocking the view of the ocean. And of course, it got very frustrating for them, because then despite the positions that they have voiced, when it went up to the Guam Land Use Commission, the Land Use Commission went ahead and approved the project anyway. But in fairness to the Guam Land Use Commission, they approved the project with certain conditions. And those conditions really weren't, not much spoken about what those conditions were. That if, we approve it, provided that you upgrade the pump station here, and they upgrade the lines, and you have to widen the roads and all that stuff. And so that much is not talking about. But even despite that, the concerns that were raised by, in particular, the advocacy group, Save Southern Guam, was that, okay, great, they put all these conditions on, but then after the thing's built, nobody comes around to check to see whether these conditions have been satisfied. Now, earlier I indicated that, in principle, I agree with Bill 318. I think it has gotten our attention that when a development is going to go on in a village, it really should be the people of the village to decide whether they want to keep everything as a single-story building so that the view to the ocean is not obstructed, or whether, fine, build all the 10-story buildings that you want. We want that. They should be the one to decide that. And I think Bill 318 does that. It catches our attention and it points us in that direction. But I have some concerns with Bill 318. I think we need to flesh it out more, because it basically says, here's where we are today. The Guam Land Use Commission, which sitting on it are people from the north, are deciding what kind of development goes on in the south. And the only input the people from the south have is, we really don't want that here, but okay, thank you for your input, and move along. Now, so Bill 318 basically says, from now on, the impacted village will have the final say as to whether development will happen or not. But it's quite a quantum leap from where we are today, and it says, go over there. That's the direction that we want to head. But it doesn't give us enough guidelines as to how do we get there. And so what I think we need is the bottom line is we want that village to have the say-so, some more authority than it has right now than just to review and recommend. We want it to be able to have a vote in whether that development is going to occur or not. And then on top of that, it's not just that village where the development is going to occur. There's surrounding villages. There's the village that's upstream from it. Maybe for the, let's say for the village of Jonia, maybe they may agree to a certain development, but the village to the north of that may not, because of the traffic impact, the impact on the utilities. Maybe they won't. Maybe they don't agree with that project. So where's their voices? So what I would suggest is that, instead of bringing that GLU, the commission authority down to the municipal planning council, maybe we should bring the elected mayors that represents those villages up to the Guam Land Use Commission and let them be part of that voting body. So I have, we have a bill that's coming up, and it's very much related to this. I know we don't normally speak about another bill, and that still remains?
Yes.
Okay, fine. So then here's how I would suggest we flesh out Bill 318. We want to achieve the objective of giving some more direct say to those villages that are going to be impacted by any development going on. So let's take, for example, that we have a project in Talafofo, right? So then and it's a project that's going to meet a certain threshold, let's say $5 million. And when that threshold is met, if we have a project that's going to have a total value, including the purchase of the land, the cost of construction is going to meet a $5 million threshold level, it will automatically impanel a hybrid land use commission. And what that hybrid land use commission would be is that you would have the 5 members of the Guam Land Use Commission, 5 members who are appointed by the governor, who are confirmed by the legislature. And then you would have added to that 4 elected mayors. The mayor of the village of Talafofo, where the proposed project will occur. And then also, at the recommendation of that particular mayor, we'll add on 3 additional mayors from the surrounding municipalities. From the municipality of Inarajan, from the municipality of Jotnya, and maybe even from the municipality of Maritzo. So you would have these 4 mayors, and now you would have this hybrid panel of 9 members. And those mayors would now have a direct input to the Guam Land Use Commission. I'm not talking about Bill 335. I'm talking
about. But you're
about
leading, I hope, into an amendment. Is that what you're doing then?
No, I'm just articulating my vision of how we might flesh out Bill 318 if an amendment was going to be made to that effect.
That's
So
very
those
familiar.
so those see it's those details, I guess you could say, that will put me in the comfort zone as to how do we get from here to the point of giving that direct authority, more authority to the villages to have a say in what development goes on in their village. And so that's the kind of fleshing out that I feel is needed for Bill 318. Now, do I want to make an amendment? No, I don't, because the next bill that comes up outlines that very fleshing out that I just described. Thank you, Madam Speaker.
You're welcome, Senator Ada. Mr. Vice Speaker, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, while I admire and I support the passionate and impassioned speech about democracy. I think we all have to stop and recognize that besides a democratic form of government where everybody votes, we have, from our Constitution, established a Republican form of government where the democracy has decided that some power is going to be given to a more central government. This bill, and I think we have to understand the precedent that it sets, does the requirement that a zone change, a variance by the GLUC is invalid because it does not have an MPC approval, also mean that that should be in our standing rules, that we can't do any zone changing in this body without an MPC? There was a time in the past where we had to get the GLUC's some kind of statement in before, at least that was a Quisqueñas one, to have something on the record that the GLUC spoke on some of the zone changing that we're having. But I really want us to stop and think about that fact. And the fact that we've gone to the democracy, the absolute, the people rule. Please remember that it's not only developers that want to do things. Under the NIMBY, if we were to try to do Luzon now, a new landfill, which MPC would approve it? And could this legislature, in spite of the objection by any of the municipalities, decide that we're going to put a new landfill? It doesn't even have to be a landfill. It could be a new multi-purpose stadium, as is being envisioned for the future. But as we've seen in the States, cities fight against it because some of them want it for the employment, and some of them say the traffic is too much and they don't want it. Areas. Who makes the final decision? It may not even be a multi-purpose facility. How about the expansion of a power plant? Can we transfer 41 acres to expand the power plant and the sewer treatment plant without the approval of the adjoining municipality? Who has the, and I'm just saying, I mean, I understand it, and yes, a democracy is great, but we don't vote on everything by the people. The people elected a certain group of us, 15, to make a decision. And if we're going to insist that everything has to go back out, then there really is no need for this body. We'll just have everything by initiative or referendum. And whatever the democracy says it is, then that's it. If a village decides that it doesn't want to have to change a zone to agricultural so that you can put up a medical marijuana plantation in the village? It affects all kinds of things. It affects whether or not this body can make a decision on whether or not we can set aside any property for a naftan or for a cultural village in a certain village without the approval of the MPC. The ramifications are widespread, and we've got to make a decision on where the power lies, or who should make the final decision. Because this way, upstream or downstream, somebody's going to say no. And with NIMBY, somebody has to finally say, for the good of the entire island, it's going to be here, and we will compensate you with an additional 38 cents or whatever. But we really have to stop and think about what the precedent that is being set by this. Because we can't just say, well, just for them, for the GLUC, because then everybody's going to come to the next legislature and ask for a zone change because there's no requirement. Thank you.
You're welcome. Senator Blas, you recognize.
Thank you, Madam Speaker. Madam Speaker, while I support the idea, that is proposed in this legislation, as a matter of fact, earlier in this term, this body passed and was signed into law legislation that I had authored that allowed the MPC to be an integral part of a process to provide their input and recommendation. I see, and I have to agree with the concerns of the previous two speakers, with what the unintended consequences could be to this. Let me add to that. Are we now going to require MPC members to file financial disclosure forms? Think about it. We are now going to give them the power to be able to decide as to whether or not a zone change or a variance application can move forward by their vote. Let me just get very blunt. How do we stop then somebody who's got interest in it from influencing the vote at this level? And nobody has any means of being able to validate, clarify, or even look into it. Madam Speaker, we here in the body, other than getting elected by the electorate, we're required to file financial disclosure forms to tell the people of Guam, to show where we get our income from, why we get our income. Members of the GLUC do the same thing. The mayors. What is that for? It's definitely not to show just how rich we get when we are in these positions, because none of us get rich here. A process was put into place so that there is a method and a means to be able to show that your vote is not being influenced. Very simply. So, while I can agree with the concept and the idea of allowing them to do this, I think that we have to step back a little bit first and then look at first off what their primary responsibilities are today. And if we're going to do this, possibly add on that new requirement for financial disclosure form, because now they will have the power to be able to make this decision. So, I can't even propose them, because even if I was to propose an amendment to allow them, to require them to do this, it's ingermane to this bill. So, maybe we need to go back to the drawing board on this. And recognize that, and address that. And I'm not to say that the ones that are, that members today, that exist today, I'm not going to assume or say that it's going to happen to them. But are we going to wait until it does happen? Or do we address it now when we all recognize and realize what it could happen? We address it now so it doesn't happen. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motion, Senator Torres, you recognize.
Thank you, Madam Speaker. This is a very straightforward bill, and for the reason that it's so straightforward, it has a lot of more red flags, I think, than anything. The retiring speakers spoke a lot to the concerns, and I think that the concern that I want to just emphasize that is captured in the committee report through testimony provided by Attorney Oliver Berdallo. In his testimony, he points out, and this is really the heart of my concern and perhaps my objection to this bill. Attorney Berdallo articulated in his written testimony that one of the things that is wrong with this bill is that no rules, standards, or guidelines are set forth in Bill 318-33. So there's no rhyme or reason as to whether the MPC will simply take a vote and decide on a case-by-case basis whether to allow a particular project to go forward. Projects can be blocked for any reason or for no reason at all. But I think if you think about our processes in a government, there's always the process of review, and there's also the process of appeal or review upon decision, and that's something that is afforded to us by law. With this bill, though, no findings would be required to support or explain the MPC's disapproval. But more so, no higher agency or court would have jurisdiction to review their decisions. So you wonder whether, in all fairness to both parties, there has to be a set rules as to why a decision is rendered. And then if the person who's aggrieved so desires to have their say and to appeal the decision, this bill doesn't provide for that. So I want to just state for the record that I live in the South. I've lived in the South for 20 years. My family owns large tracts of very pristine property in the South. So I understand and I value the South. But I also value our democracy and the process by which things have to be transparent. And if decisions are rendered, that the rules are very clear, the rules of engagement are clear, and that we also are afforded the privilege to appeal or to have the decision reconsidered. I think that the bill falls short of that. And I understand the intentions of the bill. I listened in at the public hearings, and I can't disagree with the concerns of the community, the concerns to have their voices be heard and to have their voices matter. I agree with that. That's necessary. But I think that the means by which we are trying to achieve that objective is not accomplished by 318-33 as written. And I would caution the body to not go forth with something that is really a thumbs up or thumbs down and has that type of finality attached to it, because that is not the way our system operates. And we cannot impose policy that is so absolute that it really does a disservice to some parties and does not level the playing field for all parties involved in any matter. Situus Maasi.
You're welcome, Senator. On the motion, is there anybody else who would like to speak? Senator Underwood, you're recognized.
Thank you, Madam Speaker. You know, what we're really dealing with this bill, the opposition to it, and as well as the author's reasons for proposing it, really has to do with two fundamental decision-making processes. If we leave it up to the GLUC, we're really talking about a top-down, more centralized decision-making process. What is being proposed, Bill 318-33, is more of a bottom-up, that there would be opportunities for those who will be affected by the decision to provide input. And not just to provide input, but to have that input, to give that input some weight. The previous speakers have also spoken about the need for us to ensure that those that are making the decisions would not have a conflict of interest. We want to make sure that the decision is clear. And I believe that we want to have decisions made that at the end of the day is to the best interest of the people. You know, Madam Speaker, you and I as educators know what we have gone through with different decision-making processes. We've gone through trying to decentralize the schools, so that at one time we even said the schools should make decisions, primarily about what occurs, because you know what? The decisions that they have, if they're empowered and they're given the resources, they're the ones who are being impacted. And then we have also been subjected to the centralized decision-making processes. And neither of those really work perfectly, because the people, individuals who are making the decisions, are just like the rest of us. They try to do the best they can. And we could never really ensure a perfect decision-making process because we are all imperfect. I believe that this is a good effort for us to engage those that are going to be affected by decisions that that will be very difficult to reverse. Once a decision is made about a building going up, and that building turns out to be something that is detrimental to the environment, to the people who are living there, it's going to be very hard to reverse that building. It's unlike what we have in decision-making processes that are fluid, in which we can amend it, we can say, okay, let's make this better. When it affects the environment, it's a little bit more difficult to reverse. And those who are living in that area, including those within the perimeter or the surrounding areas, are the ones who have to live with that. They have to live with the traffic as noted. They have to live with the new building. They have to live with additional population. And so I believe that as much as possible, we should afford those individuals, the citizens of that area, as much opportunity as possible to provide input, and input that would weigh, that can make a difference in the decision, the final decision. I too would like to ensure that those that represent and are included in that decision-making process are clear-minded, they have the interests of the people at heart, they know about the environmental impact, that they're really good decision makers. But as I noted earlier, it's hard to ensure that. I would like to propose that with this bill to include that somehow maybe we can have a sunset provision that would say we would put this into place and have it work for 5 years and revisit it after 5 years to see whether this type of decision making is really effective in representing the interest of the people. I offer that sunset provision because I know we've made decisions in the past. I've offered it in bills that I had proposed because even though I have the best of intentions, sometimes it just really doesn't work out the way we envision it should work out. So as a matter of compromise for those who are concerned about the quality of decision making and the impact, whether we are going to subvert our current governing system, whether we would complicate it, I would offer that we support this, but would just have a sunset provision of 5 years, 10 years, whatever that is. And that, Madam Speaker, is what I would propose at this point with this bill.
Senator, you're going to have to decide whether it's 5 or 10.
Okay.
What is your...
All right, let me talk to my colleagues.
Okay, so take a
If
brief
this is even...
recess. 5?
Okay. Yeah. I'm
Okay,
just saying that we may
one
want...
moment. We're
Okay.
back into session.
Okay, in a quick consultation with the author, I would propose an amendment that would have a sunset provision of after 5 years
Okay, so on
from the time of enactment.
On the amendment, so that would be a new section added on with a sunset, we don't need to print something out. So on that amendment, are there any objections? Vice Speaker, you recognize on the amendment.
I don't have any major, I have two pieces of property. One is 500 square meters and one is a condo. So I'm not worried about huge tracts of land, but I'm just saying this is going to stop all kinds of development. I just want us to understand that for 5 years, without an MPC approval, a power plant may not be able to be built. A sewage treatment plant may not be able to be built. A decision has to be made by some government that looks out for the interest of the entire island. And so I just really, I know that earlier, at least during the public hearings that we had, there was talk of there would be a moratorium for 2 years. But even that, I'm just concerned. It really points out the fact that we've got to have a land use plan that does the entire island, and everybody knows where things are going to go. People know that when they decide to buy a piece of property, that there's a possibility that it can be a hotel, or if I buy a piece of property for a home, that it's going to be next door is not going to be a sewer treatment plant. Or if you're going to build a nursery, the building next door is not going to be a massage parlor, whatever. It really points out the fact that we need a land use, a comprehensive land use plan. But to stop everything for 5 years pending MPC approval for each one is really going to be, it's going to stop commerce. And I know that's strange coming out of my mouth, but I'm just concerned about what the impact is going to be on any kind of development on this island. Can we invite anybody down to build a hatchery next to on government land or on private land if the MPC decides no, we don't want to have a hatchery on?
Senator Atta, did you raise your hand? Okay, and then I have Senator Argan.
Madam Speaker, I guess the concern that I have with an amendment like that is that it seems to convey the notion that maybe we're not really sure about what we're doing. And so if we're going to introduce policy, I think we better make sure we do our homework real well and have a great degree of confidence that what we're doing will work. And if we do need to come back and make adjustments, it's going to be for minor adjustments. But it just does not give me that sense of comfort that, well, let's try this. And if it doesn't work, well, I think it conveys the wrong message. And so I certainly would object to this amendment. Thank you.
Senator Argan, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, I love the nature of the discussion because this is really how legislation is formulated. Just a couple of, first of all, I stand in support of the amendment, and it's not because I am uncertain about the process. It is because if, in fact, within that 5-year window, the members either of this body or of future legislatures decide that perhaps they want to take a different route or be a little bit more expansive, then that's an option that's available to them. That's how I read it. It's not questioning whether, in fact, this proposal to empower the Municipal Planning Council, whether there's some uncertainty. No, because I believe in empowering our people, even to the level of the Municipal Planning Council. Another thing, Madam Speaker, and with all due respect to our fellow colleagues, the previous speakers, there was a statement that was made. This is going to stop development. Madam Speaker, how will this stop development when you are taking the process and you are incorporating the Municipal Planning Council members into the decision making? They have to, by an affirmative resolution, provide concurrence to any proposal.
Can you will have an opportunity to close, but right now, please just stay on the amendment.
And let me also say this. No, but I'm staying on the amendment, Madam Speaker, in regards to the 5-year timeline. But I believe that some of the statements need to be rebutted on. Like, for example, a sewage plant. No one's going to want a sewage plant in their backyard. Guess what? There's a $60 million upgrade and expansion of a sewage plant on the south because the southern community knows that it's needed. And have you heard a negative comment from that? Absolutely not, because the people in that jurisdiction and the people in the south recognize that that's a needed service to our community. So to me, with all due respect that I say that twice, genuinely, to question and impugn the integrity of individuals who are sitting in the MPC about their decision-making power,
Senators,
and whether in fact they are concerned about the type of development.
Senator, I'm going to rule you out of order if you're not going to stick to the time limitation.
Thank you, Madam Speaker.
As a point of personal, I never impugned anybody's integrity on any MPC. I was just pointing out the precedent that was being set by this action, and to have us stop and look at it. If there was, did that development have a MPC approval? If it didn't, could it move forward now? We have 4 bills on today's agenda that have other things. Without MPC approval, can we or should we pass them?
Senator, yes, your point is well taken. On the amendment, there is, okay, Senator Morrison.
Madam Speaker, I rise in support of the amendment. I think the amendment has been proffered because there's a lot of speculation being made here in regards to this process and how it would be played out. And I think if we were to base a lot of things on speculation, I mean, like, certainly there'll be a lot of more amendments proffered along the way. Madam Speaker, but we can definitely deal with what's occurring right now. And I believe the time frame being proffered is fair. Like anything, we've just spoken about previous bills about coming back to review a certain process, if it's working or not. Madam Speaker, we can certainly say without a doubt that there is issues with the existing process. That's why this bill has been proffered. When your residents or this amendment is being proffered, when amendments or where our citizens are taking our investors or developers to court, you know, and you're seeing that trend take its course, at least with result with Pago Bay. I can certainly say that even with what took place in Agate, that this is going to be 1,000 times much more greater as we proceed with any types of developments down south. Just a result of going to our village meetings that you took part of, Madam Speaker, in Arahan. So this time frame that we're talking about here is as a result of a lot of speculation being made. Would it be this? Would it be that? Would it occur? So yes, coming back in 5 years, taking a look at this is fair. To see that if it's working better than the existing process, which we all can say without speculation, that is having challenging issues right now. And it's only going to be far greater going further down south. So I stated earlier, yes, it's the judicial review process is part of the process, but that's not where we want to be. That's really the last resort that anyone wants to be. If it's we were speculating, talking about projects and this time frame. Certainly, we're seeing what's occurring with the judicial review process and how that can stall progress. Thank you, Madam Speaker.
You're welcome, Senator. Senator Espodan.
Thank you, Madam Speaker. Madam Speaker, I stand in opposition to this amendment, and only because it's being proffered to address the concerns that were raised on the main motion, on the bill. It didn't solve anything. It says, well, let's experiment anyway. And so they had this amendment does not address any of the potential unintended consequences that have been articulated this morning. It doesn't address the issue of financial disclosures and the possible ramifications the possible ramifications of not having something like that in place. It doesn't address the issue that the Municipal Planning Council, with all due respect to all the good work that they do and the duties that they're mandated to fulfill, were not elected by the people of that village. They're appointed officials, right, who are to work with the mayor. And they're usually, at least most municipal planning councils that I've seen, are very closely aligned with the mayor, as opposed to a real representation of the various interests and concerns within the community as a whole in that village. And I can go on and on and on. The essence of what I'm trying to say is that this amendment does nothing to address the concerns that were raised on the main motion of this bill. With that, Madam Speaker, I oppose this amendment.
On the amendment, is there anybody else? Senator Underwood, to close.
Thank you, Madam Speaker. Yes, as with all other amendments, this amendment to have a sunset provision is really intended to provide a means through which those concerns are addressed. As I had noted, there isn't always a perfect bill. And so to the extent that concerns were noted about the fact that even proffering this amendment just indicates that we don't really know what we're doing, I just disagree with that. I just know from experience that we can have the best intentions. But we have to monitor something like this that would affect the lives of people, the environment, and the decision-making process, whether it actually will work to address the concerns of those who have indicated the problems with the bill. I don't quite understand how empowering the Municipal Planning Council can stop development. It seems to me that by empowering them, from what I heard from those who had opposed the amendment or this bill, is that the Municipal Planning Council does not have decision-making abilities to participate in this process. And even if they are not elected, even if they were appointed by that mayor, the mayor was elected by the people of that village. So again, there's a consultation that would occur, and that mayor would be held accountable by his or her people. I am really, Madam Speaker, in support of engaging our community as best as we can Yes, they have elected us. But to the extent that when it comes to decisions that affect their lives, their homes, the environment where they sleep, the environment where they live, where they're going to raise their children, we have to expand that decision-making process. And so, again, I propose that we have an amendment, a new section that would put a 5-year sunset provision to Bill number 318-33. Thank you, Madam Speaker.
There are objections. I'm going to call for the vote. So all in favor of the Underwood amendment, which is to put a 5-year sunset provision, please raise your hand. The amendment failed. On the main motion, is there anybody else who would like to speak on the main motion? Senator Uggan, would you like to close?
Thank you very much, Madam Speaker. First of all, I extend a direct apology to the Vice Speaker. If I use the wrong terminology, impugn someone's integrity, that came out incorrectly, so I extend my apologies to him for that. It's just, I take it personally when people question sometimes our members of the general community in terms of how they would otherwise act. Madam Speaker, you know, it's been, like I said a little earlier, it's been a very good conversation. A conversation piece where, in fact, we have a proposal before us that would modify to some extent any development in any village, island-wide, by empowering the Municipal Planning Council and the mayors in ultimately making that decision. Yes, it's a change in an approach. One of the concerns was, are we going to require a financial statement? I was waiting for an amendment, you know, because yes, absolutely. If individuals are going to be empowered to make this decision, then that could be a consideration or requirement for them sitting in the Municipal Planning Council. Another concern that was raised was whether in fact there are rules and guidelines, and there are rules and guidelines already in the law that says zoning and variances must comply and be consistent with the following provisions. So, Madam Speaker, some of those issues are and should be rightfully addressed, and I appreciate the discussion there. But you know, Madam Speaker, we're not talking about an event, a one-time event that's going to occur and we need to construct a temporary facility. We are talking about developments that could indefinitely exist in that particular municipality or that particular village. We're talking about a development that if in fact we allow a hotel development in the south, that's going to significantly impact the infrastructure, whether it's the roadway because of the increased traffic or vehicles traversing in that particular area, or it's the wastewater system requirement, or it's the water lines that needs to be expanded from 6-inch to 12-inch to accommodate such a huge, massive development, or even if it's a power additional requirement. The residents in that village are the ones that will be impacted indefinitely. It's not a hotel that's going to come out 1 year and in 2 years it's gone. That's why this is very, very critical, Madam Speaker, to me, in terms of how we approach development in the future. Because the people, the residents in that village should have a say. Not, hey, provide a resolution, and by the way, the process doesn't necessarily require it, so if you don't give a resolution, the Guam Land Use Commission is going to go ahead and proceed. No. Because that's how the process works now. If a resolution is not provided, which is already part of the process before the application review committee completes their assessment, but if it's not provided, okay, decision is going to proceed. But here, it would require that any approvals of development or zone changes and variances would necessitate an affirmative support by resolution of the Municipal Planning Council. To me, I don't consider it a novel idea. It's not something that just came in and said, hey, let's change the process. No. It's about empowering those who would be impacted the most. And those are the people in that village. So, Madam Speaker, really that's where my position has always stood on this particular issue. And it was just more pronounced as a result of the incident that occurred several months back. But it was that incident occurred, and there's a purpose behind everything that happens. And perhaps because the purpose is we as a community, in my case specifically, have to be reminded of who we serve. We do not serve to accommodate a developer without directly addressing the concerns of the residents of that village. Also, Madam Speaker, I certainly reach out to you and to our fellow colleagues to support this legislation. I understand it's not perfect. And yes, we can make adjustments as we proceed forward and the MPC makes decisions and ensure accountability, ensure responsibility, ensure transparency and openness in some of these decision-making processes. Those are issues that can be worked on. But I want to say this much, because I believe so much in empowering our people, especially as we proceed with the anticipated level of development that will occur and impact this island over the next 10 to 20 years. And I say that literally because of all the activities that are going to be taking place. Not only the continual expansion of our tourism industry, not only inclusive of the military build-up. Those are going to invite developers to be able to make sure that they participate in some of these activities. And because of that, it's very important that the Municipal Planning Council, on behalf of their immediate residents in that village, be empowered. And that's how much I believe in this, Madam Speaker. And I certainly hope that I get the support of our colleagues in this initiative. And I have to say this much, because I believe in it, that should this policy, proposed policy, not receive the support of the members of this body, I will be introducing a legislative referendum to ensure that our people ultimately make that decision, whether they want the MPC on behalf of their fellow village residents to ultimately make decisions on developments. There could be thresholds, but on developments, period, within their villages, because it's the right thing to do on behalf of our people. Thank you very much, Madam Speaker.
You're welcome, Senators. On the motion to send Bill 318 to third reading file without any objections, so ordered. We will recess until 2 this afternoon. S33, Mr. Vice Speaker, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I move that Bill 187-33 is substituted by the author on the floor, be placed in the third reading file, and I ask for an opportunity to briefly address the bill.
So, Mr. Vice Speaker, I know that what's here says as corrected by the prime sponsor, but I understand what was just passed out before we recessed now is the bill as substituted by the author on the floor. So this would have to be accepted first then?
Yes.
Okay,
I'm sorry.
so can we get that motion?
And the reason for that, can I explain why it's being substituted?
No, just let us accept it first.
Okay, I move that we accept Bill 187-33 as substituted by the sponsor on the floor.
Thank you. So on that acceptance, no objection, so ordered. And now if you want to do your placement.
Okay,
and then you can
I
explain.
move that Bill 187-33 as substituted by the author on the floor be placed in third reading.
Okay,
with
and
this
now,
short opportunity.
yes, thank you. And now you may go ahead and explain.
Thank you, Madam Speaker. Madam Speaker, I know that it looks imposing. Bill 187 was a request by the Board of Accountancy that was sent to me early last year. I introduced it, but when it went to the committee, we realized that it was improperly, it didn't show the underlines and where the changes were going to be. And so I had to ask the Board of Accountancy to go back through the entire bill and show where all the amendments were going to be made. What is being proposed in Bill 187 is that the Guam Accountancy Act of 2003, which was last amended in 2006. Several years have passed, and it is now imperative that we update existing Guam laws to incorporate the changes that have been made by the Uniform Accountancy Act nationwide. These changes are reflected in the bill. 1, it updates and clarifies educational qualifications required for candidates for the CPA exam. 2, it updates reciprocity requirements relative to national and international mobility standards. 3, it updates definitions relative to evolving professional accounting standards and standard-setting organizations. 4, it updates the Guam Accountancy Act for changes in the computer-based CPA exam administrative procedures. And 5, it clarifies the existing Guam Accountancy Act as originally passed and amended to date. The first major change is the updating and clarifying of educational qualifications for the candidates for the CPA exam. Previously, at least a college level, including a bachelor's degree, would have been enough. Now, as national standards have changed, a 150 semester hour of college education will be required. Although this major shift is apparent in the national arena, and we are attempting to ensure that the same standard is kept alive here on Guam, there is a 5-year grace period immediately following the effective date of this act, which means that those currently attempting the CPA exam without the 150 hours will have 5 years to pass it and get licensed prior to this act taking effect. The accounting profession takes no exception in the expanding global marketplace, and the CPA license is something that the national and international community has come to acknowledge. CPA licenses that are licensed in many other jurisdictions in the United States have mobility standards that allow CPS to cross borders and perform certain services. Moreover, this legislation ensures consistency with national professional accounting standards and definitions. Bill 187 also reflects the updated computer-based technology through the interested applications taking CPA exam. As with this legislation, it is imperative that the lawmaking body review policy that may be outdated, and I appreciate the research done by the Guam Board of Accountancy, ensuring the completeness of this bill. At the hearing, Mr. Dave Sanford, the Executive Director of the Guam Board of Accountancy, and Mr. Onodera, the President of the Guam Board of Accountancy, both appeared at the hearing, and they both spoke in support of this piece of legislation and how important it was to improve the standards and to make sure that our CPAs, after the 5-year grace period, are going to be able to practice in other states if need be, and if we need services here, that there's mobility back and forth. And there was a whole series of questions that were posed, and in the committee report, it details all the answers that many of the issues that anybody has. The committee report on the testimony from that day explains the entire bill. I could read it into the record, but it is in the committee report, and I ask that you assist, that this body assist me in assisting the Guam Board of Accountancy update its 2003 law so that it comes into compliance with national standards. As I understand it, all 50 states have done it. The only ones that haven't done these updates are the 4 territories. And so we'll be the first of the territories to do this, and for the good of the practice of our CPAs, I ask the body to please support the passage of this legislation.
On the motion? Is there anyone who would like to speak? Are there any objections? Yeah, they're all basically updates to bring it up to U.S. standards. There being no objection for it to be placed in the third reading file, so ordered. I'd like to recognize on Bill 335, Senator Tometa.
Thank you, Madam Speaker. Madam Speaker, I move to place Bill 335-33, COR, as amended by the Committee on Transportation, Infrastructure, Lands, Border Protection, Veterans Affairs, and Procurement. And I'd like to speak on it.
You may proceed, Senator.
Thank you. Madam Speaker, Bill 335 is actually seeks to provide more direct representation of the municipalities on the Guam Land Use Commission for under certain circumstances where a development or a land use application has been put in that will take place in a particular municipality. And so this was and so basically on page 2 in section 2 you'll see the amendment that we've made here basically to the existing Guam Land Use Commission, was previously known as, in the law right now, it's referred to as the Territorial Land Use Commission. So we're updating it to the term that is actually used now, which is the Guam Land Use Commission. Now, the Guam Land Use Commission as it exists today consists of 7 members that are appointed by the governor and confirmed by the legislature. So Bill 335 proposes to downsize the size of the number of individuals that are appointed to this board from 7 to 5. Right now there's only 4 members that are sitting on the that are currently sitting on the commission. And as I go along, you'll see basically the rationale for why we're going from 7 to 5. But first thing that the bill does is it restructures the Guam Land Use Commission in terms of the number of commissioners. We're going to go from 7 to 5. And insofar as their terms are concerned, it still remains the same. Now, the bill proposes also to impanel what it calls a hybrid commission. And on a hybrid commission, it will be certain circumstances where we would then, in addition to the 5 sitting members on the Land Use Commission, we will add to that panel another 4 members. And these additional 4 members will be elected mayors of the municipalities. Now, these mayors or this hybrid panel would really only exist for the time that it takes to make a decision on a particular development application that is to take place. So let's say an application gets put in to build a hotel in Jotnya, and so this panel, this commission, the hybrid commission will be impaneled. The commission will go through its reviews and whatnot, and once it makes its decision, then the hybrid commission, this particular hybrid commission, will then no longer exist. It may be impaneled again later down the road when another application gets put in, but it may come from a different part of the island. Now, so these 4 mayors that will be added to the to the Land Use Commission when the hybrid commission is impaneled. The first mayor that will sit on it is the mayor of the village where this project is going to take place, or the development. The second, the third, and the fourth mayor that will sit on the council will be the mayors from the adjacent municipalities. So again, using the example of let's say Talafofo. So then the Talafofo mayor will sit on there. The Inarajan mayor will sit on there. The Jotnya mayor will sit on there. And if the mayor from the impacted village recommends that the mayor of Maritzo should sit on that panel, then those will be the four that will sit on there. But the three additional will be selected with the recommendation of the first municipal commissioner and appointed by the president, and shall be appointed by the president of the mayor's council. Now, to the question of, so when do we impanel this hybrid commission? And it is impaneled when a project application to build a certain development in a village is determined to have a total value of at least $5 million. Now, where did that $5 million come from? Actually, when the bill was initially introduced, the threshold was just $1 million, and then Department of Land Management came in and recommended that we should really increase that threshold to $5 million. So when a project application comes in and it's going to be of that magnitude, then this hybrid panel is impaneled. But then there may be situations where maybe it's just a $2 million project, but where it's going to be constructed may be real critical. And so in those situations, if the mayor of that particular village deems that, hey, we need to have more say on this particular application, then the mayor's council can petition that to impanel a hybrid commission. And so that basically is what Bill 335 does. What it does now then is it has the elected representatives of those municipalities that will be directly affected by a project. We will bring those elected representatives who have been vetted and have been elected by their people in the municipality to sit on this land use commission and receive all the information that there is to know about this project, how it would impact that particular village and the surrounding villages. And they would then have a direct vote as to whether the project will be approved or not, whether the conditions to go with that particular application are sufficient or not. Now, I know that during the public hearing, somebody was saying, well, what good is that? You only have 4 municipal representatives and you still have 5 representatives that are appointed by the governor. Well, to make that kind of an argument or that statement is suggesting that, those 5 are always going to vote the way their appointing authority wants them to vote. And I don't agree with that. I believe that every individual that has been appointed and has been confirmed to sit on this commission will make the correct determinations and come to a decision on their own. And so I think it's presumptuous to say that there will always be a 5-4 decision. So this, Madam Speaker, I think is another way of how to bring the authority and the power to determine what projects or developments will take place in the village by actually bringing in 4 of these mayors to sit on that panel and be part of that decision-making process. So this, I think, is kind of, it maintains in place the current structure that we have, and what it does is it fixes the notion that regardless of what the villages and their representatives say about a particular project that is being pursued to be constructed in the village, that, you know, it's just a recommendation and okay, thank you for your input. But now we will actually have elected representatives of the municipality to sit on the commission and be part of that decision-making process and be privy to all the information that is available to the Land Use Commission in making its decision. It will be privy to all the findings, the technical findings of the members of the Application Review Committee, which is made up of representatives from EPA, from Department of Agriculture, from the utilities, and that will give them a better understanding of really what the impact of this project that is being proposed. In addition to that, they will also be able to they will be privy to you know, the presentations that are made by the developer themselves. So I think this is probably a good compromise to how do we get more of this decision-making process and having the villages play a direct role. So, Madam Speaker, before I move on, there's a couple of technical corrections that I would like to make, or technical amendments that I would like to make. And the first one is on page 2, on line 18. I would like to make the amendment to read there on line 18. It reads, it starts with the word impaneled. 4 additional members shall be seated and designated as part of the Guam Land Use Commission. And then continues on as municipal commissioners. So it's just an amendment that clarifies that they will be seated as part of the Guam Land Use Commission. Madam Speaker.
On the amendment on page 2, line 19, to add the words after designated as part of the GLUC, and then it will continue on as municipal commissioners. On that amendment, no objections, so ordered.
Thank you, Madam Speaker. Madam Speaker, the other amendment that I would like to make is on page 3, on line 7. Line 7 right now reads, terminate when final disposition of the land use, and I would like to add the word project or application for which the hybrid commission was impaneled. So the amended, actually that's paragraph 2. So the amended paragraph 2 would be, the term of the municipal commissioners shall terminate when the final disposition of the land use project or application for which the hybrid commission was impaneled has been completed. So this just kind of, again, brings further clarification as to, you know, the life or the term that these municipal commissioners will serve.
Okay, so the second amendment, page 3, line 7, after the word use, to add the words in project or, then continue an application for which the hybrid commission, and then continue has been completed. Is that correct, Senator?
Yes, Madam
Okay.
Speaker.
On the amendment, any objections? No objections, so ordered.
And Madam Speaker, the bill, you know, really, insofar as the hybrid panel is concerned, really could have been articulated in just 3 pages. But it takes up another 3 pages, because what we did was we made the amendment to that section of the law regarding the powers, duties, and responsibilities of the mayors by adding a new subparagraph S on page 7, which simply serves that an additional responsibility, an additional duty and responsibility of the mayor is to serve on the hybrid Guam Land Use Commission as municipal commissioners pursuant to, et cetera, et cetera. So that's all that does. But we basically printed out the entire section 40112 of GCA. Thank you.
You're welcome, Senator. On the motions, anybody who would like to speak? Senator Morrison, you recognize.
Thank you, Madam Speaker. Madam Speaker, this measure is another step forward, I believe, to include our residents in our land use process, or improve land use development review and approval structure. I know there were some points made in the previous discussions on another measure, but I also stated reasons why Bill 318, or that measure, and 335 complement each other. And I know this, one of the statements we're concerned about was in the decision-making process that there was, in the previous measure, that there was no measure to ensure that the application review committee was still intact, the ARC committee, and of course the appeals procedures, which are still in place in 335. So my point is that although 318, and we don't want to discuss that as it's already done, but I wanted to speak to why I mentioned why they complement each other, because either our review or through the MPCs or through the mayors, through the approval process at the village level, we certainly now carry out at another level where you have 4 mayors that are in panel. Such a threshold hits $5 million, or that they panel this hybrid commission and ensure that, actually there's another layer, regardless of the decision was made at the impacted community, that 4 mayors will still be in panel, given that the $5 million threshold was reached, and now have another layer with other adjacent mayors working with the appointed members, giving it more thorough review, or the application more thorough review. So that's what I meant, that they complement each other with all existing procedures intact, particularly the appeals process. I also want to thank the author for addressing the issues with one of the statements made in the testimony regarding the $5 million threshold, and inserting language in there that calls to through resolution, deems that if a land application warrants the impanel of a hybrid commission, that the hybrid commission shall be impaneled. So, you know, for example, Madam Speaker, I know that even $5 million may seem to some communities small scale or a small scale type of project, but even for example, with the recent development over here at Chamorro Village with the Chamorro structures that were built for the FESPAC. Certainly, I think that cost almost $2 million. And that type of development, certainly in our southern communities, even below the thresholds of $5 million, can have be considered a large-scale project and have certainly impacts on the community's resources. And so I'm glad that that provision, that language in there to allow flexibility with the mayors. So, Mayor, again, I served on commissions, Madam Speaker, and boards, and I know the issue was brought up about the appointing authority over these boards and commissions. And I have to say from my experience, Madam Speaker, that statements have been made that as the author mentioned, that the appointing authority or the chair or the members would favor one way certainly has not been my experience. And to see that you have an impanelment of 4 mayors, I certainly know that will be an interesting body to work with, knowing that each mayor would certainly be looking out directly for their constituents and their impacted communities. So I thank you, Madam Speaker, for allowing me to speak on this measure, and I thank the author for allowing me to be a co-sponsor.
You're welcome, Senator. On the motion? Senator Tony Anda, you recognize?
Thank you, Madam Speaker. Madam Speaker, the author will yield to a question. And this is just on page 3. And I was reading it, line 22. It says, a hybrid commission shall be impaneled for projects or applications projected to cost more than $5 million. And then goes on to say, 2, if notwithstanding D1 above, the Mayor's Council by resolution deems that a land use application warrants the impanelment of a hybrid commission, a hybrid commission shall be impaneled. So is that then saying that regardless what the dollar amount is, if the Mayor's Council deems that a hybrid commission be impaneled, then it shall be impaneled?
Senator, do you yield to the question?
Yes, Madam Speaker. Well, yes, that's as I've written, as it's written there. It says if they deem that a hybrid commission should be impaneled, then it shall be impaneled, and that's because it may not be the size of the project. It could be a $900,000 project, but where it's going to be constructed may be really critical and significant to the village, such that, no, we don't want that there at that corner. Build it, but build it anywhere else. And so I would hope that, that provision would be used judiciously by the Mayor's Council, and that's their ace in the hole. If, it's never mind the size of the project, it's where it's located. And so that's what that provision is there for.
And that's my concern, Madam Speaker, is that, if we're gonna have we'll just say a loophole to where the Mayor's Council can impanel a commission at any time, regardless of the dollar amount of anything less than $5 million, and I have a concern with that, because then individuals who may not be on the right side of the Mayor's Council or on the right side of the mayor or whatever will find their projects to be hampered, because then they have this ability now to stall a project moving forward. And I think that, if we're gonna do the hybrid panel, I think it's a good idea. However, it's either we're gonna put that dollar amount up, and that's where the impanelment of the commission shall come in, the hybrid commission, or, let's just call it what it is then, and say that no matter what the dollar amount is, a commission shall always be impaneled. Thank you.
You're welcome, Senator. So are you going to do an amendment there in terms of what the amount would be?
Yeah, it's not the amount.
It's not the amount, so.
Right. So it's either, and I'll leave that to the author of the legislation to make that determination whether he wants to make an amendment to the paragraphs there.
All right. Senator, I'm not sure whether you wanted to respond to that.
Well,
No?
I can.
Okay.
I certainly understand where the retiring speaker is coming from about this. First of all, I know that at the public hearing, one of the mayors says, hey, we're so busy, we don't have time for a lot of this stuff. So from a practical standpoint, I'm sure the mayors are not going to be rushing to the head of the line to sit on a land use commission that's going to keep them up there away from their duties for hours on end. So that, I believe, from a practical standpoint, is not going to be happening. But I think that this particular provision is important because you can't always judge the impact of a project based on, the magnitude of it. Sometimes it's the location of where it is may just be as impactful. And so I would be inclined to leave that there. But if the body thinks that, this is a loophole to then to impanel a hybrid for every project that goes through, it's fine. It's a compromise that I'm willing to concede to. But it doesn't, so that's fine. If somebody wants to make an amendment to delete that, then so be it.
So it's open. You want some time to prepare your amendment, Senator? Okay, take a brief minute. The legislature is back in session. Senator Ada, you're recognized.
Thank you, Madam Speaker. Madam Speaker, after consulting with my colleagues here, I would like to proffer a couple of amendments. On page 3, line 23. And this is in regards to what is the threshold that would cause the empanelment of a hybrid commission. And so, first of all, on line 23 is to qualify this cost that we are talking about. And so on line 23, we want to make the amendment so that it reads, projects or applications projected to have a development cost of more than, and then we'll get to the amount. So by putting in the words have a development cost, that qualifies what cost we are talking about. Okay? It's development cost would exclude the cost of the land.
And then how would the sentence read after that, to have a development cost?
So then projects or applications projected to have a development cost more than, and it was suggested that we lower that threshold to $3 million.
Okay. So the amendment is on lines 23 and 24, projects or applications projected to have a development cost of more than 3 million.
No, more than 3 million, yeah.
More than 3 million. On the amendment, Senator Espadon.
Thank you, Madam Speaker. I fully understand it, and I appreciate what's being attempted here. I guess the one question in mind is the term development costs defined anywhere? Because I guess in my thinking, if an investor comes in and sees a potential piece of property in which to do some construction on for a certain type of project, does the land cost become part of the development cost because that investor does not yet own that land? And so could that be construed as, could the development cost be construed as the cost of purchasing of the land and the construction of the project as one? And so I guess the question is, and maybe legal counsel can answer for us, is development cost defined anywhere in law?
Senator, do you yield to the question?
Well, I think to answer the question, then we could further qualify with this cost by saying that to have a development cost, and in parentheses, less the cost of land, more than $3 million. So usually when we talk about a development, we're talking about the engineering work, we're talking about the earthwork, and if we make it very clear that the cost of that real estate itself is not included, then I think we've narrowed down what's in that development cost.
Which is true, which is the objective of my comments right now. How do we, what is going to be that exact language to exclude the costs of the property?
I guess this question is it in any other section in the code?
No, it's not. But I think we can address this concern by further qualifying this cost by adding the verbiage in parentheses, less the cost of land. So we talked about the cost of development, which is generally understood to be the earthwork, engineering, the vertical construction, but then we further say less the cost of land.
1 minute, Mr. Speaker. Maybe perhaps
right.
counsel might be able to guide us on this one.
Thank you very much.
Correct terminology.
We'll take a short break.
Thank you.
We're back on the record. Senator Addy, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, in consultation with my colleagues, I'm taking the recommendation to make an amendment to line 23, page 3. This pertains to the threshold to be established to impanel a hybrid commission. And so line 23 would read, projects or applications projected to have a development cost exclusive of the cost of the subject real property of more than $3 million. So what we've done with that amendment then is we've made it clear that the cost of real property that project is going to sit on is not included in this $3 million threshold, and it will just include the cost of development, which is understood to mean the engineering costs, the earthwork, and the vertical construction.
On that amendment, any senator wish to be heard? Senator Espaldon.
Actually, I like the amendment. I just want to make sure where the punctuations might be, if there is any punctuations. Only because it makes a big difference.
And it reads then, projects or applications projected to have a development cost, comma, exclusive of the cost of the subject real property, comma, of more than $3 million, period.
Thank you, Mr. Speaker. I just wanted to verify that it was there in appropriate places, if there was any at all.
Any other senator wish to be heard on the ADA amendment? Any objection to the ADA amendment? There being none. Back to the main motion. Any senator wish to be heard?
I apologize.
Senator Addick, you're recognized.
So on back to page 3, because of the amendments that we made in D1, I would like to move to go ahead and delete all of D2.
On that amendment, any senator wish to be heard? Any objection? There being none, D2 is struck. Any other amendment? Senator Adams?
I'd like to go ahead and move it down into the voting file, Mr. Speaker. Thank you.
Okay. Any objection to placing the bill in the voting file? There being none, can we take a short recess? Next on the agenda is 285. Does everybody have a copy of it? Can we see that all the senators receive a copy of Bill 285, please? I think, is it next?
Yeah, 285 is out. Okay, Senate. Oh, okay.